It's a great pleasure to invite everybody to the second series of our seminars this year. Our guest is Professor Edoardo Alice, and Edoardo joined Centro as a extraordinary professor last year. He's written extensively, and why we were particularly happy to have him in our ranks is that he's a sort of interdisciplinary scholar, both in areas of politics and law. So he has a wide perspective on these issues that we're dealing with. And certainly from our informal discussions and the contributions he's made to our previous seminars, that his wide-ranging insights are really helpful for comparative debates. I'm going to ask Edoardo just to briefly introduce himself before he starts. I've had a bit of technical error and I can't pull up his CV at the moment, but if he can just spend some time giving us the basics and then continue with his talk. My apologies for that. Over to you, Edoardo. And after he's spoken, Mario Jacobs will respond.
Thank you. Thank you, Paul, for the kind words. Yes, I am I'm professor of labor law, industrial relations in Naples, in Italy, and I teach as well social and labor market regulations, which is a topic more related to social policies. So this has to do with my background as a political scientist and as a lawyer that allows me to jump and to be in this condition of having several perspectives on different social policy or labor law industrial relation issues. Thank you for having me. It's a pleasure to share with you some thoughts about this crucial and topical issue of representation and action, collective action of self-employed. In the last meeting, we had already a discussion, a very lively discussion on the international framework and the South African situation on this topic. I would try to propose something which can be complementary to that discussion, starting, of course, from the consideration that, in my view, and this is a vision shared by many of the participants to last meeting, in my view, of course, the exclusion of self-employed from the scope of application of collective rights is basically against the ILO conventions and more specifically the loss of any juridical and empirical and logical grounds. Of course, the major point here is two major points. From the one hand, the social perspective or the industrial relation perspective, in which is not always to be taken for granted that these self-employed or autonomous or independent contractors, they really like and need to be collectively organized and represented. But on the other hand, there is the juridical issue, the fact that going behind what they desire or they need, of course, the legal order, any legal orders, or at least the multi-level perspective, there should be a chance for them to unionize, to organize, and to act collectively. Also in the perspective of having collective bargaining, or at least collective agreements, which define some basic common working conditions. So the reflection on the real attitude for these workers, we should say, to be collectively organized is something that I would leave to them to decide in a legal framework which allows them to organize if they want, if they need, if they so desire. So in a way, this is a typical issue that could be seen from different angles, but at the end of the day, the fact that the legal order provides for freedom of association and freedom to bargain collectively, also in the view of fixing some remuneration of their activity. It's of crucial importance. My perspective today would be also to offer a short overview of some very recent developments at the European Union level. First of all, because of my hemisphere of origin, of course. Secondly, because I think that in a way this development or these changes that we may observe within this supranational body as the European Union may be of some interest and some help for the ILO and the ILO Committee of Experts in supporting the case of the entitlement of self-employed to collective rights. It is, of course, difficult, if not impossible, in a few minutes to provide you with any kind of synthesis on the situation in the European Union and in the member states of the European Union. But in any case, there is a very lively ongoing debate on the boundaries of labor law. So the question is whether labor law should limit itself to employees, so to workers as employees, or if labor law should go further and be applied to all the protections it usually entails to outside the employment relationship. And of course, in this point, it is clear that the definition issue and this kind of definitory ballet starts. Everyone has his or her own opinion of the boundaries of the employment relationship, the notion of self-employment. And of course, this is not only a clear juridical issue, this is also how the reality has developed and how the labor markets are now configured in the perspective of making such a distinction clear and undisputable, if not undisputed. Of course, further to the definitory issue, there is the point of competition law. Competition law is was, at least at the beginning, an unexpected foe of the collective dimension of self-employment labor relations. Maybe when everything started at the European Union level, it was not that clear that the idea of having kind of overlapping between the undertaking and autonomous work, self-employment, was so dangerous or so meaningful in the perspective of collective action of self-employed. So the idea that self-employed were all service providers, and as service providers they fell within the scope of application of competition law, which prohibits any kind of cartel or collective regulation of market condition. Was not that clear maybe at the very beginning, but it is rather clear that since at least a couple of decades, 3 decades, this is a major issue when it comes to the EU level, but also at national level, for the unionization and the collective organization of self-employed. So for anyone who is not supposed to be in an employment relationship, because this is, of course, the main issue. And and this is since competition law at European level is a matter of EU legislation, there is an exclusive competence of the supranational level. It became, of course, a national problem in all the member states. Also because the so-called independent authorities, which are regulated in the member states' national level competition law, they were very eager to attack any essay of self-employed or people not in employment to organize. So it was this kind of authorities that they started procedures and proceedings against self-employed who try to organize, who try to be part of collective bargaining and agreements. And it was then for national courts to ask to involve the Court of Justice of the European Union as a supreme body interpreting EU law, to involve the Court of Justice just in order to know if this attack, this negative attitude towards unionization, collective bargaining, collective action, self-employed, was justified at EU level. And the answer that the Court of Justice European Union provided was rather disappointing for people like me and us who support the collective action of self-employed, because the court was very clear in saying, well, if they are real self-employed, if they are genuine self-employed, well, there is no chance because they are undertaking under EU competition law. So there is no chance for them to have a legitimate aspiration to collective organization and action. That will be against EU competition law, because since they are undertaking, they cannot build up a cartel. The court admit, well, maybe in some cases there are faults self-employed. So people who for different reasons are labeled as self-employed, but if we look in practice to their the main features of their work relationship, we discover that there are actually employees according to national law or even according to EU law when it defines workers in opposition to self-employed or service providers. So this rather disappointing position, I think, was not surprisingly adopted with reference to musicians, and that's bring us back to the first seminar we had, because musicians, of course, they sometimes they are employees of the orchestra. In that case, was the Royal Dutch Orchestra. Sometimes they are substituted of the employees in that orchestra. So they entered the orchestra as self-employed because they used to work under the label of self-employment. And they would like to, of course, profit from the wage setting, the collective agreements provided for employees of that orchestra. So it is clear that there are some sectors in which this issue is particularly hot, because of course there is a clear possibility for people to work, to exercise the same activity as employees or as self-employed. Since that decision, which dates back 10, 15 years ago, the debate at national, at European, national level was very heated because it was clear that and this is the social policy aspect, that self-employed, autonomous workers, service providers, independent contractors, they try hard to define themselves as a collective, to define themselves as something more than a sum of individuals, and they try to organize. They organize actually, but the point is that their collective agreements are against competition. Very recently, and this is my second point for today, very recently the Court of Justice was called once again to decide on a very broad and sensitive issue, which is not necessarily linked to self-employed, which is the application of EU legislation on EU anti-discrimination law. It was a case of discrimination on grounds of sexual orientation, a Polish case in Poland. A member state with some problems, let's say, with the general approach the EU member states have towards the fight against discriminations and equality on the ground of sex, sexual orientation, and so forth and so on. And this is a very interesting decision of the court, because the court was called to decide whether this anti-discrimination legislation applies also not only to employees, so to people in employment, but also to people outside an employment relationship. And I would like here to share briefly my screen in order to show you something that's not is here. I hope you can see it.
It's all good, thank you, Prof.
Yeah. I will try to make it as a presentation. Yes. And this, just to give you briefly the context, because the context is interesting in order to understand what kind of self-employment or what kind of condition outside employment the court was talking about. And it was a very specific case of somebody providing its activity as an independent contractor, but within was the broadcasting sector, within a series of short-term contracts for a specific work, which is of course a limitation. I'm aware, which is a strict limitation of our perspective. So it's not self-employment in general. It's somebody who is in a rather strict relationship with one contractor, and in these 7 years they had several short-term series of short-term contracts. And there was also, so that this self-employed, if I may say, this worker was actually integrated within the organization of this broadcasting company, this TP, which is a public owned broadcasting company. So there was also a kind of organization, a coordination of this autonomous activity with the structure of the broadcasting company. There was a kind of shift between at least two self-employed workers. So it's not a general reflection what I will propose to you, but there is something I think interesting also for the rest of self-employed to be highlighted. What is interesting here, if we leave aside the big technicalities you can read on the slide, but the point is that the Court of Justice says, well, at EU level, we may have two different approach to work relationships. There is one approach which is the typical focus on employment relationship, in which it is clear that a worker is the weaker part of the contractual relationship, and it is protected by labor law, one could say. And there is another aspect which is related to anti-discrimination law, in the sense that anti-discrimination law seems to have a wider scope of application, even when it comes to work relationships. So it applies a contrario, let's say, not only when an employment relation is at stake, but and when there is a weaker part of this relationship, but also when there is something different, which I keep on calling self-employment. Indeed, in the idea of the court, this kind of anti-discrimination legislation is focus on any form of work, in the sense that focus on the capacity to contribute to society through work, irrespective of the legal form in which work is provided. And this is a very, I think, a very important assumption. And from this assumption, it follows that the protection conferred by this anti-discrimination legislation does not depend upon the categorization of an employment relationship, and the fact that there is clearly a kind of contractual relationships. Well, if this is very promising, because it means that there is a protection outside employment, outside the employment relationship, does not mean, and this is maybe the most interesting but also the worrying part of this reflection, it does not mean that anything which is outside an employment relationship could be protected by a labor law, we could say, or by anti-discrimination law, if you like. But here there is a necessity, says the court, to distinguish activities falling without the scope of anti-discrimination law, and from those activities consisting in the mere provision of goods or services. And this is the crucial point. So we should think that we have at least two different kinds of self-employment or autonomous work, in the sense that from the one hand, there is a provision of goods or services, which is not deemed to be to fall within the scope of application of anti-discrimination law, I should say. And there is another part of self-employment which does fall within the scope of application, and maybe does fall within the scope of application of labor law in general. And this happens when the activities are generally pursued in a context of a legal relationship characterized by a degree of stability. I think this is the most interesting point, the crucial point, this position of the Court of Justice. So that we need a certain degree of stability of the relationship. Should not be a spot relationship, the provision of a service once and never more. There should be a kind of framework, of legal framework, contractual framework, within which this relationship is continuously renewed, which is, of course, a very strict limitation of the scope of such a reflection. Well, what's the case at stake? When could we say that there is this kind of continuity? Well, you can really hear some indicators. I don't want to go too much into detail, but the idea was that this person was for 7 years involved in this kind of self-employment relationship, provision services, within which his performance was also assessed and positively evaluated by the broadcasting company. So this is something in between, if I may say, the employment relationship, the hierarchical subordination, and the autonomy, the provision of service, an activity which is in no way linked to the organization of the contractor. Something that is not unknown in the European landscape, at least if I see it from an Italian perspective, because we had since decades this kind of coordinated work, coordinated autonomous work. Well, in this case, says the court, this is a relationship that falls within the scope of discrimination. Coming back to the core issue of this presentation. Well, how does it impact on the collective dimension? Well, it is clear in my view that if we kind of self-employment like the kind stake in this decision, well, it is rather clear that not only an anti-discrimination law, but also labor law and collective labor law should apply. And this could be of some help, for instance, if we broaden a bit our view from the broadcasting sector, for instance, to the food delivery, to be of some help in recognizing the right of so-called riders to unionize, even if they are deemed to be self-employed, because they are clearly in this kind of framework relationship or series of relationship and contractual relationship with a platform, if not with the customer. So to conclude, I apologize for being probably too long. There is a hope. I think that there is this decision of the Court of Justice is not decisive at all, but it seems to me that it opens up to a different consideration of the juridical situation and also the needs of self-employed, even if it is restricted to people who are not false self-employed, but clearly are in a way integrated into the organization of the contractor, not in a hierarchical perspective, not in a subordinated way, but at least their activities coordinate by and with the activity of the contractor. So thank you very much for your attention. I hope it could help in clarify this very difficult relationship between labor law and self-employment.
Thanks very much, Edoardo. And thank you. No need to apologize. You certainly kept to the time frame and for such an incisive overview of those European developments. Let me do a better job of introducing our respondent, Mario Jacobs. Mario is at the Law of Development and Governance at UCT, which is also interdisciplinary, both being in the commercial law department and sociology. And Mario, before pursuing his research career, was for 24 years a union official. And he now has 2 master's degrees, one from UCT and one from a Brazilian university, and is pursuing his PhD besides his full-time job. And proud to say I was one of his lecturers during his UCT master's. Over to you, Mario, to respond to Edoardo's talk and to give us some domestic perspectives.
Thank you for that rather generous introduction. I'm not sure that I'm worthy of some of those comments, but thank you. I want to start by saying the following. I find myself attending a civil society meeting in Accra, and the discussion is around the African Continental Free Trade Agreement. And I mean, Edoardo was speaking about competition law, and over the last few days, we've been dealing with competition law, investment and trade regimes and the like. And you find representatives of civil society organizations arguing that collective bargaining in many instances stifle both investment as well as trade between countries. So I find that rather strange. One would expect civil society organizations to advocate for a greater form of collective bargaining that should exist within their nation states. But then again, we all may not have similar views around some of these matters. I've asked the central staff to share my presentation. I'm doing a presentation simply because I'm hoping people will more focus on the presentation than to hear to say on the subject. So Ivona or Leonore, if you can possibly share the presentation. So following on from Professor Ali's, my job is to sort of bring the discussion home in the context of South Africa, but more looking at it from a collective bargaining lens. So if we can move to the next slide. Can we move to the next slide, please? Okay, so what is the problem? I think we generally accept that in terms of employment law, including that of collective bargaining, that workers deemed to be independent contractors or those engaged in non-standard employment relations are outside of the scope of labor law. So the protection that labor law offers them, or certainly offers those classified to be employees, doesn't apply to those deemed to be independent contractors or generally those who works in external employment relations. Now, what role should trade unions play in terms of advancing the interests of workers, whether they are core workers or falling under the periphery? Now, I think it's important to make the point that organized labor in South Africa for the last 2 decades developed or adopted a resolution where they profess that they will begin to organize and bargain on behalf of workers falling in external employment relations, your informal category of workers or workers are deemed to be independent contractors. Unions have not been able to do so. We see some developments taking place in other parts of Africa. In fact, next to us in Zimbabwe, unions have started organizing informal workers, workers that are deemed to be independent contractors, but we're not seeing that taking shape in South Africa. And part of that is the definition of a trade union in the Labor Relations Act. Now, a trade union is an association of employees, meaning if you are not an employee, you're not in a position to belong to a trade union. You can call yourself by whatever other name, but you're certainly not in a position to either be a member of a trade union, alternatively for a trade union to recruit you as part of their general membership base. Now, taking that to the collective bargaining space, we should go to section 23, dealing with labor relations in general, but subsection 5 of the Constitution of 96, and there it is stated that every trade union, employers organization, and employer has the right to engage in collective bargaining, unquote. The effect of that particular constitutional provision is that only trade unions or employees' organizations and an employer can engage in collective bargaining. So in the case of Zimbabwe, where that particular legislation permits for workers' committees to be established, you don't have a similar provision either in the Constitution or in the Labour Relations Act. In South Africa, it is only a trade union representing the interests of workers that can engage in collective bargaining. No other form of organization can engage in collective bargaining. And obviously, as I pointed out earlier, a trade union by definition is an association of employees, thereby excluding independent contractors and similar forms of workers. Next slide, please. There are, however, some positive developments. For example, the National Minimum Wage Act that was passed in 2018, came into effect on the 1st of January 2019, covers all workers. So that would include an independent contractor, an own account worker, etc. It draws distinction between what we just spoke about now, which is an employee, and another category of workers. So the National Minimum Wage Act is the first piece of labor legislation that has a broader definition of work being performed as opposed to that which labor law concerns itself, that is being engaged in employment relationship. So that is certainly a positive development. And Paul made mention central session, but I think it's important to also note that there are current discussions taking place at the level of the National Economic Development and Labour Council, where the social partners and certainly based on a proposal submitted by organized labour, that they want to review the definition of employee in all labour statutes to ensure that the coverage of atypical workers and non-standard workers are indeed covered. The understanding from engagements with organized labour representatives is that they seek to have something similar to what is contained in the National Minimum Wage Act. I must make the point to say that these are initial discussions at the level of NEDLAC, and it will be premature to suggest what the outcome of those discussions may result in terms of a resolution on either a new definition or, as we nowadays call it, hybrid definitions of what that may mean in the future and how that is to be applied. Next slide, please. There are obviously existing legislative provisions that could be relied on. And I made the point here that legislative provisions exist in a number of areas. And without necessarily going into the detail of that, the one concern I think that needs to be expressed is the extent to which, in the example of Section 83 of the BCA, organized labor or civil society organizations are in a position to, let's call it, persuade the minister to deem particular categories of persons to be employees. So Section 83, subsection 1 of the Basic Conditions of Employment Act permits for the Minister of Employment and Labour to deem any category of persons specified in that to be an employee. And naturally, what flows from there is if those categories of persons are deemed to be employees, the general application of labor law will apply to them. Next slide, please. So what is happening in the collective bargaining space? And the question is posed, do we have some form of provision where independent contracting workers are currently protected by existing minimum wage instruments, collective bargaining instruments? And I want to make two examples. The one is sectoral determination 7, which is a sectoral determination covering domestic workers. Just for those that may not know, a sectoral determination is issued by the Minister of Employment and Labour for particular sectors or areas of the economy, and it normally follows an investigation previously done by the Employment Conditions Commission, now undertaken by the National Minimum Wage Commission, and it set down certain minimum employment standards that must be complied with within that particular sector or area for which the sectoral determination becomes applicable. So in case of sectoral determination 7, which covers domestic workers, it also covers independent contractors. So in terms of that particular scope, it specifically mentions independent contractors falling under the provision of the sectoral determination. So that is done under the provisions of the Basic Conditions of Employment Act. When you seek to, move to the Labour Relations Act, the National Bargaining Council for the road freight and logistics industry makes provision for some parts of that particular collective agreement or main agreement apply to independent contractors, or the wording they use is own account workers. So essentially, says much the same in terms of the nature of the contracting party or parties. So there are some bargaining council provisions, not just within the National Bargaining Council for the road freight and logistics industry, but others also covering the scope of independent contractors within the parameter of particular bargaining council. It is also noteworthy to note that the National Minimum Wage Commission recently published in the Government Gazette and asking for interested parties to make representation on establishing a sectoral determination for healthcare workers. Now, I noticed that the interested individuals, as part of a particular webinar, that I'm sure will make representation on that particular investigation. There may very well also be an argument that healthcare workers should simply be absorbed within the public service. In fact, there was an interesting judgment delayed the Gauteng Division Court by an acting judge called Paul Benjamin, who in that particular application determined that those workers indeed should fall and be employed by the Gauteng Health Department. I've certainly not seen similar judgments or judges being brave enough to issue rulings of that nature, but whether we are less comfortable with there being a sectoral determination for health workers, I certainly think it is a step in the right direction, where workers previously deemed to be independent contractors will certainly enjoy some form of protection, and hopefully organizations organizing within that particular space would be able to further advance the collective bargaining agenda of healthcare workers and similar kinds of workers in such kinds of services. The next and I think the last slide. Can we move to the next slide, please? Not that one, the one before. No, there's one last slide before the end. Can anyone hear me?
Sorry, Mario, I'm just getting to that slide quickly. Is this it?
The one day after.
That one?
That's bargaining councils could not cover certain businesses. And here I make the road freight and logistics industry. Now, the scope of this bargaining council includes the move a particular item to point B for reward. That's covered under the scope of the
Sorry, Mario,
point
could
B.
you please repeat that? You're breaking up.
We don't have load shedding here. I'm making the example of the National Bargaining Council for the freight and logistics industry, and in particular the scope of that bargaining council, which includes the delivery of goods from point A to point B for reward. And you look at a company called Take-A-Lot or similar companies. The nature of that particular company's business is the delivery of goods from point A to point B for reward. I would argue that even though that company would operate within the space of what people call a platform economy or the gig economy, that the nature of that particular business could easily fall within the scope of the National Bargaining Council for the road freight and logistics industry. It does, however, present a number of problems. One is that if you were to locate them under that bargaining council, the question of representativity of both the employer component to that bargaining council, as well as the representativity of the trade unions to that bargaining council becomes a contested terrain. Already, the unions within that bargaining council as its total representation just over 20%. And I can say that because, I mean, we currently, and one of the data we looked at was the status of bargaining council representatives significantly dropped, meaning that there's greater reliance on the employer bodies in order for that bargaining council agreement to be extended. So I'm making the point that one, you could probably locate a company like Take-A-Lot to fall under the scope of that bargaining council. But if you do so, it raises a number of other questions. And I think these are the kinds of matters that warrant further research and investigation to see the extent to which we are able to find ways and means to either one, protect, and secondly, advance the interests of those workers deemed to be in. I will stop there.
Thanks very much, Mario. Thanks for a very detailed and thorough response, locating both the broader debates and I think one of the points you make is that the question of protection is often a complex issue in raising different issues in different sectors. Thanks for your kind words on my judgment on the healthcare workers. Since then, I haven't been invited back to act in the Labour Court, although I don't think it's got anything to do with that judgment. I did put in a note to indicate if anyone wants to contribute to the debate, but I hope none of you will be offended if I immediately ask Manfred Weiss if he would like to contribute, having a scholar of his international reputation and generosity in our seminars is an honor. So I think if you wish to add something, Manfred, please do so.
Well, thank you, Paul. First of all, I fully agree with my friend Edoardo. He has given you a very good perspective of what's going on with us. Well, if I may add a few comments. The first one is that, of course, we have to not only question labor law and ask the question whether we have to extend the coverage. We also have to question competition law, because we have to go back to the reasons why we do have competition law. And we do have competition law to make sure that there is fair competition, meaning that there will be no power structures, no monopolies, no oligopolies, and so on. But this, of course, has nothing to do with the kind of musicians who are self-employed, And therefore, I think we have not only to adjust labor law, but we also have to adjust competition law. My second remark refers to the powers of the European Union. Unfortunately, the power to legislate on collective bargaining is not with the EU, for reasons which I can't go into. When we had the reform, the amendment in 92, the so-called Maastricht Amendment, these things were excluded. By the way, on a push, the employers' associations and the trade unions, because they wanted to keep out the EU from collective bargaining, from strike and lockout, and from pay, which I think was a big mistake. And this, of course, now leads to the fact that the European Union only can make recommendations. What should be done? How should this be treated? And then they made a sort of communication where they say, okay, we cannot legislate, but we will not intervene if in such and such and such cases, self-employed are included in collective bargaining, which shows you the kind of, legislative problems the European Union as a supranational entity has. I think I leave it with this. I could make lots of comments, but we don't have time for that.
Thanks, Manfred. Is there anybody else wanting to put their hands up? I see, Edoardo, your hand is up. Do you want to respond?
No, it was just an applause to Manfred.
Oh, okay. All right. Anybody else? Don't be daunted by the Debbie Collier. Your hand is that's a hand. Debbie,
That's a
our
hand.
director.
That's a hand, Paul. So maybe just just in terms of ILO developments and where they're going with the instruments and what is the impact of it. You know, the convention, if you look at the convention one, for example, the scope of application, it's, you know, how do we kind of work backwards? And if we are looking at providing protection in the world of work, I don't have the convention in front of me, but, you know, it makes reference to member states ensuring that workers who are covered by the convention have the opportunity to engage in collective bargaining. It's almost kind of the future trying to, you know, changes to the past. How do, you know, does that give us an inroads, or does it, I don't know if I'm really making myself clear, but it, you know, it seems like the more recent instruments are more progressive in the sense of covering workers more broadly, but how do we get that to talk back to instruments that have been more restrictive? So that was just really one observation more than, but maybe Edoardo and Manfred have, you know, kind of thought about that a bit more broadly in their context. But then also, just Mario's comments about civil society's responses in the context of discussions around the Continental Free Trade Agreement, which is a little bit concerning, you know, about the potential impact of collective bargaining on trade, investment, and competition law. And I wonder if that's unique to our context, where, you know, collective bargaining and trade unions are seen as a barrier and therefore something to be regulated, or if that's kind of been seen in other regional arrangements. So yeah, just two thoughts really.
Mario, I see your hand is up.
Yeah, no, Debbie, I agree. It's concerning, especially coming from civil society organizations. But let me introduce something that I know Manfred has got a particular concern about. And I'm not saying that in a bad way. Foreign law. I mean, we just recently completed on the German due diligence within the O2 value chain in South Africa, Ghana, and Kenya. You have this United Nations guidelines on corporate governance, corporate social responsibility. You have the law in France. You have the EU directive, similar legislation in terms of the UK modern slavery, and so forth. Interestingly, many of those instruments, and to us that would not international law unless it become. So our legislative framework allows for our courts to consider foreign law. But over and above that, social responsible legislative framework that exists in other parts of the world is imposed on us. And it gets imposed on us because of the value chain that exists between the headquarters of whatever company let's use Mercedes-Benz Africa, which is Daimler in Germany. So when you supply Daimler, you must complete certain human rights standards, including environmental standards, including labor standards. So it recognizes the right to freedom of association, and more importantly, it recognizes the right to engage in collective bargaining. It's a more positive right to the right that we have in our labor framework. And Daimler or Mercedes-Benz Africa must ensure that they comply with those provisions. Naturally, if there's a dispute about the application thereof, then the domestic law takes interpretation over the law that exists in Germany. I make this point simply because it's an entry point. And if you are able to put pressure on the Works Council in Germany at Daimler, for example, you could have a situation where the subsidiary is compelled to follow what the Works Council direct them to do if unions in that particular space is not in a position to get the rights that otherwise would have existed. I'm making that as an example, and I accept that, yes, it is foreign law, but foreign law or the application of foreign law is provided for both under the Constitution, under the LRA, and I think it's a means that one could use to at least get your foot in the door, so to say. Let me stop there.
Okay.
Hi, Edoardo, and then Manfred, can you contribute?
Yeah, I would like to say.
Yeah,
May
please,
I?
Manfred. Please, Manfred, go ahead.
Okay, well, Mario, you may remember that last year in Stellenbosch, I already reacted to this, and I agree with you. But therefore, I think we should not have these kind of laws of the different countries for global value chains. We have, as you know, an initiative going on in the United Nations Human Rights Council. And there we have already now the third draft of the working group. And if you look to this graph, it would really, well, react to what you say. The problem is only that so far, we do not know whether that draft ever will be a convention, because, or an international treaty, I should say, because there is enormous resistance by the industrialized countries, I have to say. And we have to overcome this kind of resistance, and then we might get a sort of global structure where we do not impose anymore things on other countries, but where we have a sort of structure which is globally agreed. This, of course, would be the goal we have to achieve, but it's not easy to achieve.
Thanks, Manfred. Edoardo?
Yeah, I would like to react to Debbie's comment. Well, I think that above all, in some specific fields like safety and health and harassment, as you mentioned, like anti-discrimination law, there is a clear trend to make the categorization of work relationships irrelevant. So there is a clear trend to an application of those provisions to whenever form and kind of work or occupation is concerned. So the answer is yes from the one hand, maybe from the other hand, when it comes to working condition which has a sense and an impact from the economic point of view, that could be more difficult. And I totally agree with Manfred when he said competition law should ask itself what is the real meaning of some restriction, and what is the real meaning of imposing restriction on people who have clearly nothing to do with any entrepreneurial initiative as such. Let me say something about this legislation on value chains, and well, I think that's and there again I totally agree with Manfred. National legislation is a bad medicine. It's a bad medicine because it also has a risk of neo-colonialism.
Yes.
So the fact that when you, if I understood well, you, Mario, you said it is imposed. Yes, it is imposed, and this is a point you cannot forget, because I think that it's very dangerous to make such transplantation of industrial relation models legal approach in countries with different history and also different outlook on the future. So it means that this is something that comes from the outside, and even if foreign legislation is accepted by the courts, it doesn't mean that the courts could be really able to apply it or to interpret it in a positive and effective way. So I'm very reluctant, and I'm very positive towards this international or supranational intervention. If I could say, I would prefer a regional intervention instead of a broad global one, because also in that case the compromise will be very, very difficult to reach, and the result may be not that effective. That's it. Thank you.
All right, everybody. Can I just throw the floor open to anybody else who would like to contribute? I don't see any hands, but if anyone wants to raise a hand. Manfred, any final words from you?
No.
Well, thanks. Yes, well, thanks very much, everybody, for once again a very interesting and stimulating debate.